Good evening, everyone, and welcome to Crime Talk. My name is Scott Reich, and I want to thank everybody for joining us. It is our evening Tuesday night show. We do it every Tuesday night, 6 p.m., obviously with a few exceptions. A couple weeks ago, we couldn't do it because we were in trial and felt like I really had to focus on that, even though I would rather have been here, I assure you of that. So we have a lot to talk about, like we do always. There's always so much stuff to go on. And it's kind of interesting. Obviously, the case that first jumps to my mind is now we're back kind of to the Lori Vallow, Chad Daybell matter. We had the Alex Murdaugh murder trial that went for 6 long weeks. Sometimes it seemed like it was never going to end, but they did, and the jury wrapped it up rather quickly. We can certainly talk about that as well. And then, like I said, we have the Lori Vallow, Chad Daybell matter. We were scheduled to start the trial. I was at August or April 6th, I think, is when they're supposed to begin a joint trial. And then late last week, the judge, to my surprise, severed the cases. So Lori Vallow and Chad Daybell will now have separate trials. Now, remember, this is something that Mr. Pryor, who is Chad Daybell's attorney, has wanted from day one. And it's good strategy on his part. He kept plucking away. And we talked about the court's order the other day, and it really didn't make a whole lot of sense. He kind of went through the factors and, if it's going to be prejudicial and there's basically, co-defendant statements aren't going to be admissible, whether a defendant can testify as to one count but can't testify to another count, then therefore there should be severance. Kind of went through the whole severance joinder analysis under Rule 14 of the Idaho Rules of Criminal Procedure. And then he said, due to all the forthcoming discovery, we're going to sever the trial. That was it. Now, remember, Mr. Pryor has been arguing for a severance literally since the case began. He's made numerous arguments, filed many motions moving for severance. And then all of a sudden, the judge says, okay, fine, you can have your continuance. Now, I understand he has to balance, the rights of the accused and the rights to a fair trial, et cetera, all that kind of good stuff. I get it. But it really makes you wonder what changed. What really changed? What came forward? Was it some sort of testing? I mean, the DNA has been ongoing in the Lori Vallow, Chad Daybell matter from the beginning. Now, I get it. Lots of state labs do not start testing DNA unless it's really imperative to, like, for example, an identification issue early on in a case. They do not do it until a trial date has been set. And the reason why they do that is, DNA testing is expensive. It is very time consuming. And there's just a very limited number of labs and qualified people that can do it. So they have to triage and they say, well, does this one really going to need, DNA testing? Is it really going to go to trial? Anything along those lines. So the thing that I think is interesting is that here we have the situation where what the hell has the government been doing for the last 3 years? They knew this case was going to trial. They knew deep down in their hearts that they were going to go for the death penalty for both Lori Vallow and Chad Daybell. Why were they not testing this stuff? Now we get reports, intermittent from hearings that take place, unless somebody's sitting in there. I guess there's some audio delayed or something to that effect. But the judge, because the prosecution, I get Lori Vallow didn't want her attorneys. I don't think Lori Vallow cares. But Lori Vallow's attorney said, we don't want the cameras. It's going to create a spectacle. A circus will be had, and no one will get a fair trial, and we'll just wind up doing it all over again. Really? Look at the Alex Murdaugh trial. Look how efficiently that ran with cameras. I think they made a mistake at the very end when the trial was over. They The cameras showed Alec Murdaugh walking in custody in front of the jury, and some of them, which, okay, mistake, no big deal. Most of them have already talked to the press. I think 4 of the 12, I guess it's not most of them, but a third of them have already talked to the press. So what's the big deal, really? And so I don't get it. I think I've said this before. You can go way back. It's not just me. And, not the first time, because, Lori Vallow's trial isn't going to be tried, on TV. I think that cameras should be in all of the courtrooms. I think you should literally be able to go to a directory and literally watch whatever's going on in any courtroom anywhere. And if they're not going on, why is there no business going on in the courtroom? Most courtrooms I know are busy enough that they should be going literally full time. They have enough work to do. And I think that the cameras should be there. I think the people should be able to see what takes place in their courtrooms. How are the prosecutors prosecuting the cases? Is the judge up there calling balls and strikes? Are they being fair judges, or are they, biased in some particular way? And, is the defendant receiving representation that is quality representation, or is he getting railroaded in some way because he's got, for lack of a better term, a terrible attorney, right? Let's so let me do this. Let me take we have a super chat here, and it's kind of like when you get a text message and it's there, and you're like, I'm not going to look at it, and then you just think, I gotta do it. So what's the status of allowing cameras in the courts? Do orders that apply before severance still apply? Good question, Laura, and thank you for the super chat. We don't ask for them, but they certainly do highlight. As you can see, it got my attention there. I was like, oh, I gotta answer that. So yes, courtrooms, cameras, no courtroom cameras. Now, late this afternoon, Judge Boyce has issued order governing conduct, the Ada County Courthouse and the Ada County Overflow Viewing location. So it says, in order to provide an orderly disposition of this case, because everything about it has been so orderly, hasn't it? This order shall govern the conduct of the public and the media in the Ada County courtroom where the jury trial is proceeding, as well as the overflow viewing room in the Ada County Courthouse. This order shall supersede any prior governing courtroom conducts in this case and may be amended from time to time. The court is mindful of the need to balance the constitutional rights of the defendant to a fair trial, the public's interest and right to information in conjunction with certain constitutional and statutory rights for the public to attend the proceedings. And third, the court's interest in maintaining order and an environment which permits all participants to focus on their responsibilities without the undue distractions, and for the court's interest in the safety of the jurors and the public and court security personnel. With these factors in mind, the judge notes, and he draws your attention to the Idaho Court Administrative Rules 45 and 49, and there's going to be seating in attendance in the Ada County Courthouse. And certain seating may be reserved for members of counsel, authorized court personnel, security personnel, and the defendant's family and victim's family. Public seating, subject to the need for reserved seating in reference 1A of this order. Seating for the public will be permitted on a first-come basis, subject to a reservation system to be administered by the trial court administrator's office in Ada County, subject to approval by the 4th Judicial District Judge. Details and instructions how to access the reservation system for seats within the courtroom where the jury trial is conducted will be published at the following website. All right, get it? Here it is. Go to https://adacounty.id.gov/judicial-court Vallow Daybell trial. Beginning on or about March 7th, 2023, there will be no priority or designated seating for the media. No person may reserve seats except those through the reservation systems, and there will be no standing in the courtroom. No standing. There will be no standing. No standing. Frank, put us on the reservation. We're going. Okay? Beginning on March 7th, which is today. We need to let's look at the calendar. We're going. Since we're not going to be there, at least we can do as a member of the public, we need to go and be good spectators and good members of this, the community, and let Judge Boyce know that we've been watching. We're watching you, Judge Boyce. And guess what? We're going to report back and say, wow, cameras could have been in there and we wouldn't have had to go to Ada, Idaho. Although, it's lovely there. It's lovely. I mean, going to Boise. That's going to be fun. If we could just get old Crime Talk 1 back here. Formalities, but one way or the other, we're going. Tomorrow, let's book a couple of hotel rooms. Let's look at the dates. We're going, okay? We're going to do lives. Make sure we have something that we can do lives out on the front courthouse. Didn't we get press credentials? Because we're like press, right? And we're practically press. I mean, we bring you the facts. We don't put any spin on it. We just tell you the way it is. Look in the comments, Kay Woodcock, for those who aren't familiar. Jury selection starts April 3rd. Trial should take 2 to 3 weeks. Yeah, man, that's a surprise to me, but thank you, Kay. And obviously, Kay, we're with you. I know you're frustrated by the whole process. You called into our Patreon show a couple weeks ago and told us you're a little frustrated. Doesn't seem like the prosecution's exactly helping the victims in this particular case get a lot of, what's the word I'm looking for? A lot of information, and they're not really listening to their input. And I know they wanted the case to be televised because they have family that can't travel that far and take off 12 weeks. So hope that all goes well. April 3rd, Frank. Let's continue with the court's order here. Seating in front of the bar. No one other than court personnel designated by the court, the defendants, the attorneys and assistants, shall be permitted to access or sit in front of the bar of the courtroom without specific authorization from the court. That's pretty normal. Most, it's kind of, if you're the attorney or staff, you sit on that side of the bar. If you're a defendant, you wait for your turn for the case to get called up. Security screenings. All persons entering the jury trial courtroom may be subject to additional security screenings. Handbags, backpacks, and other carry-ins are subject to inspections. Cell phones, pagers, laptops, or any other electronic devices shall be turned off or be in the silent mode and shall not make any sound or create any distractions. Devices shall not be used to record, photograph, or transmit any sounds, images, or video from the Ada County Courthouse. That's a pretty standard order. Most courthouses you cannot record. You have to get permission to do so. Laptops may be used in the courtrooms if cameras and microphones are disabled. I wouldn't even know how to do that, but okay. Under no circumstances may such laptops be used for any audio, video, or photography in the court. No media interviews or reporting shall be conducted inside the courtroom, and any activity or behavior which is considered disruptive may result in removal from the courtroom. Any spectator who creates a visual or auditory disturbance may be removed from the overflow viewing locations and or the building at any time at the discretion or court personnel. I guess any activity and behavior which is considered disruptive. Define disruptive. Pursuant to Idaho Rule 615, witnesses subject to the exceptions provided therein shall be excluded from the trial courtroom. Court security personnel are authorized to check and verify names, attended, and restricted access to the courtroom. Basically, that's part of the sequestration order. Something that I didn't really understand down there in South Carolina. I've never done a trial where there has not been a sequestration order, which means if you're a witness in the case, you anticipate being called in the case, you can't testify. You can't sit in the courtroom until after you've testified and then been released from all of your testifying duties, so to speak, not subject to recall in any way. I was very surprised that they let everybody sit in the courtroom there in South Carolina. The only exception normally is advisory witness, which is usually, say, for example, in a homicide case, you get to ask, or you ask that the lead detective sit there with the prosecutors. So, if there's something that comes up, he's right there. Makes complete sense. The defense always has the right to have an advisory witness as well. So if you have an investigator that's worked on the case, a paralegal, they can be an advisory witness. And, and then experts. Usually experts get to sit in and testify. You could sit and testify with the when the other experts testify on the stand. Any violation of this court order, disruptive proceedings, could result in permanent exclusions. It may be criminal to subject criminal contempt, which is the best way to handle it. Direct contempt. I saw you recording. You're using your laptop. Sheriff sees that. I'm finding you in direct contempt. And, they'll either send you to jail then or maybe set it for a hearing. Any attempt by anyone without prior leave of the court to contact, communicate, photograph, or audio-visual record any member of the jury panel respecting this case until the conclusion of this case may be punished by criminal contempt of court. Due to the public immediate interest in this case, the court has decided to allow viewing of the public portions of the jury trial at 2 additional locations. There'll be an overflow viewing location within the Ada County Courthouse to be designated by the ADJ, which may be changed from time to time and deemed necessary by the ADJ due to other Ada County needs and availability. A remote viewing location in Madison County Courtroom to be designated by the Honorable Dane H. Watkins, Jr., Administrative District Judge of the 7th Judicial District, which may be changed from time to time deemed necessary by Judge Watkins due to other Madison County needs and availability. A separate conduct order will be issued in regards to the Madison County remote viewing location. And that order went up today as well. The overflow and remote viewing locations are being offered only for portions of the jury trial that are public, subject to the technological needs and possible periodic interruptions due to technological issues. Seating may be reserved for the authorized court personnel, security personnel, the defendant's family and victim's families, the Ada County overflow viewing. Same thing with the other one. Once again, you can make your reservations. So we need to look at the calendar, Frank, and do that. Spectators with a reservation may be permitted to leave and re-enter the overflow viewing location during a court session as long as there's no significant distraction to other people. And you're going to get screened again at all these other places. There'll be a protection order. Nobody can do it because not protection, but sequestration order. And then don't do it. If you've been kicked out, you'll get contempt and you'll get trespassed. Don't do it, ladies and gentlemen. Don't do it. And then, of course, they list all of the attorneys' emails. Cracks me up. We're all secured about privacy. Don't do this. Don't do that. Blah, blah, blah. And then the judge puts all their emails out there to the world. Anyway, so that case is going to start. We've got Lori Vallow going to go on her own. No husband there to help her out. Question is she doing this to help herself out or help him out? Does it really matter? We know her defense is going to be simple. It's going to be the simple defense that we thought here at Crime Talk would take place all along. And that's Alex Cox did it. For those that aren't familiar with the case, Alex Cox is the brother of Lori Vallow, who killed Charles Vallow in Arizona, where Lori Vallow is charged with the murder of her ex-husband. And, it's not really a whodunit. It's just a question whether it was a conspiracy or not. We'll give her the presumption of innocence, but it kind of looks like it was a conspiracy. The whole thing was kind of set up. Did she play little mind games with old Alex to get him to do it? Kind of maybe seems like it. I don't know. And then we have stuff here in obviously Idaho where, what's the word I'm looking for? She's filed a notice of alibi saying that she was not at the location where the crimes took place. And that's in regards to the death of JJ and Ty Lee. Don't think that alibi necessarily covered the one for, I'd have to go back and double check it. I think they were at an apartment in Idaho And then when Tammy died, I think she was in Hawaii, was her notice of intent. So anyway, she's saying, I don't know nothing about know nothing. It's very interesting. Obviously, they don't have a not guilty by reason of insanity, but you can raise mental health issues. And then if it's found that there's mental health issues, then you can go off to the state hospital. The defense is saying, we're not doing that. And Lori Vallow's not waiving her right to a speedy trial. And I'd be curious to see. Wait here in the next week or two. We brought you the motion that was filed by the defense yesterday in regards to the motion to dismiss the death penalty. And their big issue is dismiss the death penalty. We don't kill witches anymore. And don't do that. But their other reason is they said there's been so many discovery violations that the prosecution has bait stamped over 80,000 documents. So I'm assuming that's pages, 80,000 pages. I mean, if you do cases long enough, you're going to get a case that has 80,000 pages. Most of it's irrelevant, probably duplication. So let's get real. It doesn't take that. It's not, that's all the stuff they have to turn over everything. So is it really 80,000? Yes, you have to review it, but is 80,000 of it all relevant? No, it's not. So let's get for real. Now, apparently the government has admitted this past week that there are more statements of a co-defendant as requested in discovery that still need to be copied and supplied to defense counsel. Defense counsel don't know what we don't have. It could easily be Brady information. If there's a death sentence in this case, appellate lawyers and post-conviction lawyers will inevitably find additional discovery that has not been turned over. And the government has essentially admitted it hasn't turned everything over. Such discovery failures will cause any death verdict to be vacated and the case will have to start all over. He's not wrong about that if there's something that's not been turned over. And like I said, this case needs to go to trial. Okay. At a certain point, cases linger on the vine, so to speak, and eventually they just need to go to trial one way or the other. But you'd be surprised. And this is what I kind of want to talk about here. I don't know if there's any great trial lawyers left out there anymore. I don't know. I mean, except maybe for, yours truly. Because I was thinking about it before COVID, we were doing a felony trial a month. We were rocking and rolling. It was it. And then we had a bunch of other trials and whatever, but I was averaging about a trial a month. And then COVID hit. And I think over a period of COVID, we did like 3 trials, which is probably more than most people did, at least that I know of. And then I was talking to a friend today, and there was this talk about, basically doing some work for an agency. And he went to this little conversation, and they literally were like, we get it, you're a trial lawyer, but that's really not what we're looking for. Like, how do you do your diversity, equity, and inclusion in your law practice every day? And this attorney was sitting there saying, what the hell are you talking about? Like, we hire the best people we have, yada, yada. It's just, I don't know. But he got the feeling that they didn't want people to go to trial, that it was, why can't we just do mitigation? And we're going to go through this holistic approach as it relates to the practice of law. We're going to get the people the counseling they deserve, blah, 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 blah. And my first thought was, I didn't go to law school to be a social worker. Now I get it. It's attorney and counselor at law. And some days I feel like a counselor, a drug and alcohol counselor. I feel like a life coach. Some days I'm an investigator doing mitigation, a researcher. It just depends on the type of case. But I really get the feeling there's lots of people out there that don't want to go to trial. And it was shocking to me when they basically said, we don't want you, not to me, but to this other attorney, saying that, yeah, we really don't need you. We don't need your type anymore. I'm like, what the hell? Why do you not want, experienced trial attorneys within your organization? Because like I said, geez, that floored me. And I was literally shocked. And I couldn't imagine it. And I just don't get that, because there are people out there that, I mean, I know attorneys that have never gone to trial. Hell, we get contacted and or hired by attorneys who are like, hey, I was trying to negotiate this case. I got to go to trial. I haven't been to trial in years. I don't know what to do, blah, blah, blah. And then they come and hire us. I don't know. It's just very odd to me. I think COVID may have had something to do with it. I don't know. But I just, like, you're a trial lawyer. That's what you do. That's what prosecutors are supposed to be doing, going to court. And that's another thing that changed over COVID. As a trial attorney, it's made my life and some of the attorneys in my office a lot easier, because they were giving away the ranch on some cases. You're like, really? That's a great offer. Tell your client to take it. As a member of the community, I'm shocked and I am outraged that they would, give such a great disposition, because you thought, wow, if the public knew what was going on, which is why we need cameras in the courtroom so people can see. Really? This guy that's got like 8 felony convictions and he picked up a new case for the exact same thing, and you're going to give him probation? Yeah, you, at a certain point, you have to really think what's going on in some regard. But anyway, I don't know. The Vallow case, this thing's gone on too long. And I get there's been delays, some 10 months, but it really makes you wonder on both sides, what has the defense been doing that they're still not ready to go as it relates to Chad Daybell? Why is Mr. Pryor not ready? At one point he's like, oh, I'm thinking about getting co-counsel. You're 3 years into the case and you're just thinking about getting co-counsel? Are you kidding me? Unbelievable. Then you have, obviously, Lori Vallow's attorneys, which I thought it was a weird rule, and I don't know if I believe it, 100%. But Mr. Archibald was appointed, and was it Mr. Smith? I got his name right here. The co-counsel. We haven't really heard much from him, but he seems like, I'm John Thomas. Sorry, John Thomas. He seems like a smart enough guy. I think he looks like Chris Farley. And I don't mean that in a bad way. He just looks like Chris Farley. Anyway, so as I understood it, the state, although they appointed him, basically wouldn't pay Mr. Archibald to work on the case until she was restored to competency. I mean, doesn't that sound like a stupid rule? Isn't that the kind of thing where the court should be able to say, hey, when she's restored to competency, we want to get this case rolling, so you get to work on that case. And then, of course, she doesn't waive speedy trial. And I assure you that Mr. Archibald would love to have another 2 years to develop mitigation, find out, what he needs to do for the defense, go through every single page, review it, document it, index it, cross-reference it, engage in extensive motions practice. But his client's saying, nope, we're going to trial. And when I first saw this motion that was filed by him, motion to dismiss the death penalty, I know that he already has a motion pending in regards to motion to dismiss for speedy trial. And the whole reason the court, extended her trial date until after speedy trial had expired was because, well, the cases have been joined. It's a joint indictment. They should all be good to go, et cetera, et cetera. And now it's not. So it's going to be interesting to see how the court juggles that. Now, of course, do I really think the court is going to dismiss the case of Lori Vallow on speedy trial grounds? No. Let's get realistic. He's not going to do that. He's not going to be that guy. I'm surprised that he severed the trial, but apparently Mr. Pryor must have made a good enough record to basically say, hey, Judge, I'm going to be ineffective. And that's kind of what it sounds like Mr. Archibald is really kind of saying here is, Judge, I'm not sure how effective I'm going to be. And, more than likely, why are we going to go through the death penalty thing? We all know it's never going to happen. You can't even get the drugs. The state of Idaho can't even get the drugs to put the one person on death row that they've been trying to get rid of for 35 years. So do we really think we're going to do this? Well, I get it. It's on the books, but it's up to the DAs to change their mind. And now they're saying, well, maybe she doesn't have mental health issues. Maybe she's just an evil person. What do you think? Lori Vallow, mental health issues? Lori Vallow, mental or evil person? Mental health, evil. Mental health, evil. I don't know. Catherine has a good question here. Are lawyers allowed to ask about religion in voir dire? It depends. Now, here's the thing in voir dire. This is the opportunity for both sides, the prosecution and defense, to find who they hope are going to be 12 impartial jurors, to listen to the facts, reserve judgment, and then follow the reserve judgment until all the evidence has been concluded in the case, and then to follow the court's instructions. Pretty generic, qualifications to be a jury. Be 18. Usually you have to speak English, be a resident of the county in which you reside in, where you are for jury duty. Not know all the parties in the place, not be involved in law enforcement. General requirements, they vary by each state by statute. But that's generally the gist of it. Can you be fair and impartial, reserve judgment to all the evidence, only consider the evidence that is legal and competent evidence presented in court. That's it. Follow the court's instructions. Deliberate. You're qualified. Just because you have knowledge of the case doesn't mean you're disqualified from being a juror. Okay. Now, getting back to Catherine's question, can they ask about religion in voir dire? You can't go in there and basically say, hey, who here believes an eye for an eye, tooth for a tooth? You can't do that. However, and I believe there's a juror questionnaire that's being given to all the jurors when they show up at the courthouse. I assure you there are going to be questions of religion as it relates to, are you a member of the Church of Jesus Christ of Latter-day Saints, aka the Mormons? I don't think I'm offending anybody, but that used to be their ad, right? But some people get like, oh, they don't do that anymore. It's LDS, whatever. I think that's going to be a ripe area in which both parties can explore. Now, here's the thing, okay? Frankly, if I was the defense, I wouldn't want anybody from the LDS church on that jury. You say, why, Scott? The fix is in. All the people that say, it's a cover up for the LDS church. They're running it. Well, we have no proof of that. Okay. But let me tell you a couple of stories. Okay. Had clients, I've represented clients of all nationalities, race, ethnicity, you name it. And sometimes over the years, I've had, for example, Hispanic clients or African-American clients, and they'll be like, man, I want all the black jurors not to get kicked off. And, you see a juror, and usually it's like a younger kid or something like that. And there'll be an older gentleman up there, and this guy's been around the block. He's a wise man. And, they usually want justice. They know the difference between right or wrong. But I've learned over the years, you don't want that older African-American gentleman on your jury. Okay? Because he is going to hold that young man, the defendant, to a higher standard. I've seen it numerous times. People just don't play. Right? If I was a juror, say, for example, in the Alec Murdaugh case, would I hold him to a higher standard? Yeah, probably, because he knew better. And I think I would have been like, yeah, that guy's lying up there. He's lying. Jurors thought he was lying. But I would be like, oh yeah, dude, you've been stealing for years. You can't be trusted, etc. So you have to be careful. Jurors to think that, oh, somebody of the group that I am a part of is going to respect my position and the fix is in. No, it's not going to happen. Okay. It doesn't happen. And we were doing a trial, and it was a gun case. It was a shooting, homicide. And basically the defense was, we're a rural community. Everybody has guns. And we were kind of flip-flopping. Do we want gun owners? Do we not? But everybody has them. It's not like in the city where you can get, a bunch of people, nobody has guns. In the rural communities, everybody has guns because you've got to protect yourself from wild animals out on property. There may be a sheriff that takes, on patrol that night, but there's only 3 of them and it could take 2 hours for him to get there. You don't just pick up the phone and call the police. You have to be able to defend yourself. Anyway, we go to trial, and it was kind of like, hey, it was the gun. And the jurors struggled of it. I mean, I think they truly believed there was a malfunction with the firearm, but their position was, everybody knows you don't point a gun at somebody because in case it just goes off, you got a problem. And we were aware of that problem. We were aware of it. But it was the gun people that were the harshest because they're like, hey, man, I'm a responsible gun owner. I've gone all these years. I've never had that gun go off. And if I did do something stupid, you know what? I knew I didn't point at any person because I didn't, I followed all the gun safety rules, right? Never point a gun at anybody, point a weapon at anybody. Don't put your finger on the trigger. Make sure, what's back there. All the basic gun safety rules. And so if I was picking this jury, I mean, maybe things are different. I don't know, but I can't imagine people in the LDS church saying, well, she's one of my own. She's not guilty. I just don't buy that. I've known many people that have been LDS members over the years, mostly through my kids. I met their parents and things like that. And they were all usually, it seems like they were business owners, raised their children. They were very polite. Hell, they don't even drink Coca-Cola, for God's sakes, right? They don't even eat sugar. So I just find it hard to believe that if you get a bunch of people from the LDS church, they get up there and say, oh, she's one of us, not guilty, no matter what she did, 2 children dead, a wife of her new husband deceased, but they're LDS church, so bygones, it'll be over. Don't buy that for a second. Okay. I think they would actually be harsher on them because of the negative press and publicity that has been brought on by them. So I don't think it's a good idea. I mean, frankly, you want somebody, I mean, let's face it. If you're Lori Vallow's attorneys, who do you want on that panel? You want guys. And I know I'm going to get in trouble for this, but another lesson I learned way back when, women don't like other women. You all hold each other to a higher standard as well. And I don't know, Victoria's saying, Scott, don't underestimate the church. Maybe, we'll see. I don't know. I don't know. If I'd want guys on the panel. How does she know? She seems, they're gonna be like, oh, she's such a nice young lady. She'll probably be flirting with them, making eye contact with them over 12 weeks. Maybe probably one guy thinking, I got a shot. But I got, she can't be in custody, although she's gonna be in custody forever. So I don't know. I just don't think I don't know. I don't think that they're going to I wouldn't want females. If I was Lori Vallow's attorneys, I wouldn't want LDS church members on there. I just don't do it. I just don't see it. I don't see it. I mean, I've had cases where, you get your clients, whatever race they are, and you get them like, a bunch of good jurors on there, and they're like 4 of them, and they come back and they're just crushed. Like, how could they do that? They're one of me. They're my same race. We've got the same struggle. And it's like they took an oath to follow the law, to make a decision based upon the facts and the law. And people are shocked. They somehow think that, those lawyers, they all stick together. If I was on a jury, if I was, the defendant's a lawyer, let's just stack it up with lawyers. Lawyers are going to say he's innocent because he's one of them. Oh, hell no. And we're like, hold you to a higher standard, bud. And you making the rest of us look bad. Guilty. That's the way, I don't know. We'll just have to wait and see what takes place. But at least the case is moving forward, even if Chad Daybell. Now, if I was Judge Boyce, which I'm not, and I'm not going to be a judge and don't want to be a judge, although I used to get that question all the time. By my mother-in-law. So, have you ever thought about becoming a judge? No. Why would I want to do that? And take a pay cut? Are you kidding me? No, didn't want to do that. And frankly, most people, district court judges in the state court, usually overworked, completely understaffed. Yeah, no. Although I will make an observation, okay? And maybe I'm getting old, but is it me or what? But are these judges getting younger? I was in front of a judge the other day. I'm like, oh my gosh. She looked like she was maybe 30 years old. And I'm not, she just looks so young. And her bar number was, the distance between here and the moon, so to speak. I was like, oh my gosh, it's such a high bar number. And then here, like, okay. It was no big deal. It was just a simple guilty plea on a matter. But I was like, man, these judges look so young. And I swear it goes by so fast, ladies and gentlemen. I literally can remember my first court appearance when I got off of active duty in private practice. And I'm sitting there in the court, just kind of waiting there, trying to get my case called up. And 2 public defenders who I had, even to this day, the utmost respect for. One of them looks around and he's like, who's this Reich guy that's got a case? And I'm like, that's me. I was the young guy. Although I still probably look exactly the same as I did back then. And I can prove that. Although probably a few pounds skinnier. Now I'm the old guy walking in. Hell, there's an elected DA in a jurisdiction around here. I won't mention his name. I remember when he was a new county court deputy and I did his first trial against him. I won. But now he's the elected DA. So it makes you think, God, am I getting older or what? I was going to say doctors are young now too. The guy with more wisdom. That's right. I'm not getting older. It's true. It just goes, I'm telling you, it goes by so fast. It goes by so fast. I literally cannot believe how quickly it's gone. And then your kids grow and, you miss stuff and you're busy. And we were talking about that the other day, the lovely Miss Chris and I, how looking back, you kind of have some time on your hands. You're not rushing around racing kids to events and anything. You kind of got your life to yourself and you can pretty much go and do whatever you want, depending on work schedules. And you just think, how did we ever do it with kids and this event and that and going back and working and traveling? Like, it just went by so fast. So fast. Mystic Rogue just found out Buster filed a stalking and harassment complaints against the news. I think Daddy might have given him some pointers. We talked about that in our daily show that we did. Buster was talking about, there was a photo posted by the New York Post, I do believe, and it was basically of them inside their condo, which means somebody was taking a picture inside their condo. They contacted the police. Now, whether you like Buster or not and his girlfriend, they're entitled to their privacy as well. And they shouldn't have people taking pictures inside of their home. I'm okay with he wants to do that. I guess if the photo was taken from outside, from a distance away across the street, then maybe, there's, close your windows if you don't want, but it looks like somebody peeking in there. LVD prior to having Archibald. Let me see. Can you put up that super chat, Frank? I can't get it to. Do you think that after the Lori Vallow Daybell trial, Pryor will have Archibald join him to become Chad Daybell's attorney? No. There would be an ethical conflict there. So no. He would have confidences. Couldn't choose it. Couldn't do it. There'd be a conflict there. So let's see here. This is K. Mr. Rogue, I think she was stable household growing up. Not sure really. I know she had the same two parents and siblings in the same household. That was in response to a question that Mr. Rogue asked as whether she was unstable or instability throughout her life. Looked like she had a relatively kind of normal childhood. I don't know. But like I said, for those who don't know, Kay Vallow Woodcock is the grandmother for JJ Vallow. That was her grandson. So she's been kind enough to follow us here on Crime Talk, as well as also a Patreon member, which if you'd like to become a Patreon member, you can do so. And guess what? Then we're going to have a live show after this, and we're going to have the call in. So you can do that. Let's see here. Breaking news. Harpatulian addresses South Carolina Senate critics after murder trial. This is from Columbia, South Carolina, and it's from, I don't know, WCSC. Senator Dick Harpatulian, who represented convicted killer Alec Murdaugh in his murder trial, took to the floor of the state Senate Tuesday afternoon. The Richland County Democrat thanked his colleagues in the Senate for the emails they sent inquiring about his well-being during what he called a maelstrom of trial. He also gave his observations about the trial and the legal process as he reflected on his almost 50-year law career. Fun is the wrong word, but it's still enjoyable today for me as if it was almost 50 years ago when I began this process of trying cases. That process, if it operates correctly, can be very satisfying to the lawyers. He also addressed his fellow senators' questions about the integrity of the system. Now, I disagree with Judge Newman on some of the rulings he made. He ruled and we objected. It's on the record, he said. The Supreme Court, Court of Appeals will have a chance to look at that, and maybe even federal court. But that's not based on bias. He just had a view of the law different from what I had. It seems reasonable. I mean, that's what lawyers do. Make the record, object, goes up on appeal. The 6-week trial obviously ended Thursday with Murdaugh being convicted of 2 counts of murder and 2 counts of weapons charges. Newman sentenced Murdaugh to 2 consecutive life sentences. Harpatulian also addressed criticisms he received from people who sent messages that called him a piece of scum or expressed hope that he would die of rectal cancer. It's true, people. That's what people do. Not all of them wished rectal cancer on me, but most were fairly critical, he said. But he said he believes that those people have a misapprehension of the nation's justice system. While they're very familiar with the Second Amendment, they apparently haven't read the Fourth, the Fifth, the Sixth, and the Eighth Amendment that guarantees our freedoms of ourselves and our property, he said. You don't have to convince me you're innocent for me to represent you. I totally agree. That's not the issue. The issue is, can the state prove your guilt beyond a reasonable doubt? Once you decide that position, you are free to do what is in your client's best interest. He said over his career, he has prosecuted a case that put a man in the state's electric chair and defended a man who was sentenced to the electric chair. He said he has done both sides. I'm not a Red Sox fan or a Yankees fan. This is not what this is about, he said. So those out there, this may appear on YouTube somewhere who don't understand that. Read a book. He also had 3 words for people that had slept outside the night to get a seat in the gallery during the trial. Get some help. That's good. I have to agree with him on that. I've prosecuted a couple of cases when I was in the military. Been, predominantly defense attorney. It's not, it's the Bill of Rights to the Constitution, ladies and gentlemen. This is why I totally agree. You have to, if you like one, you got to love them all. Okay. It's that simple. It's not like it's Wendy's and you get to pick and choose the ones you want or you think should apply to you or a defendant on a particular day. It's not that way. You're either all in on the Constitution and the constitutional rights and guarantees that you have, or you're out. You don't get to say, well, I'm really for that First Amendment. That Fourth Amendment seems like it's a pretty good idea. I don't really like the Second Amendment. Never really had to deal with the third, so I could do away with that one. The Fifth Amendment, though, if they want to, use condemnation to take my property, I think that's a good one. But the defendant should always have to testify at trial because how are we going to get both sides of the issue? So I totally agree with Mr. Harpatulian. I mean, read a book, read the Constitution. It's not that long. And ladies and gentlemen, the Bill of Rights, the first 10 amendments to the United States Constitution, the most important. They are exactly what every dictator scumbag has ever done throughout history. And the state said, if we're going to do this radical concept of a Republican form of government, no, not Republican, Democrat, a Republican form of government, we actually have representatives, right? Then we're not going to jump onto this. We're not going to ratify the Constitution that just says, oh, these are the 3 branches of government. They wanted the limits on government because they know that when people are in power, they will not want to give up that power. They're going to do everything they can to take advantage of it. And everything that every dictator despot has ever done over the course of history up to that point, and it frankly continues today, look at what they do. Everything in the first 10 amendments, Bill of Rights. It's what the king and the dictators did to suppress their people, oppress their people. Oh, the church doesn't like what I did. They think I'm too mean. Oh, let's just ban the church. That religion is so pesky after all. We don't like that. And next thing you know, we got the people out there protesting against the king. Well, we can't have that. Ban freedom of assembly. Oh, you don't think I'm a good king? You want to petition the government? How dare you, you little peon? Get back to the fields and work. That's what they used to say. Freedom of the press. Oh, the press is writing things that are not nice to the king. That used to actually be the job of the press, right? To try to hold people in position of power accountable, not just the people they didn't like, but all of the people in government. That's what they actually used to do. It was a thing. It was a thing, but it was protected. Our founding fathers, pretty smart guys, said, we're not going to let the king make rules that do that. What does a despot do when they want to run over the people? They want to disarm them, take away their guns, take away their means to fight the king. So when he sends in his troops because you have disobeyed and you have not complied sufficiently, you can't do anything to defend yourself. The king used to make you quarter the troops. Make sure you feed these guys. Those horses better not get skinny. Fourth Amendment. They didn't like you, they'd go rummage through your house. Not sure what we're looking for, but we're going to keep looking until we find what we think we're looking for. We'll know it when we see it, right? Founding Father said, you can't just come in here, the government, and search and seize property. You have to have a warrant by neutral magistrate. There has to be probable cause that a crime has been committed. To do that, to go get that search warrant, to go arrest somebody. The Fifth Amendment, the king used to say, talk, tell me what you did was wrong. No, we're going to make you have a right to remain silent. Come and take your property. No, not going to do that. You have to pay me for my property. Think about that. If the dictator despot around the world wanted to take your property because he liked it, it was a better view for him, he could just take it. And they said, no, you can't have that. We have private property rights here. You can't do it, government. You have to pay us for it. Can't seize your property. Sixth Amendment, right to counsel. Oh my God. You mean you've been accused of something and maybe you're not that articulate. Maybe you get really nervous when you get up there talking. So you want to hire yourself a lawyer. Yeah, you used to not be able to do that. Have a right to a public trial where everybody could come and watch to see if the proceedings were fair. Yeah. Did the king want to have a open and public trial after he accused you of something? Right? Don't they do that in Russia, China? I think aren't they doing it to that Tate guy, Andrew Tate in Romania? Pre-detention detainment, right? One of the things, you're going to write to a bond. Otherwise, the king just throw you in the dungeon. We'll get around to it. You know that whole speedy trial thing? It's a thing. Speedy and public trial, it's a thing. Why? Because the king would throw you in the dungeon and tell you, we're not going to come get you for a couple more years because we don't care about you. So they said, the founding fathers said, we're going to have a speedy trial, a speedy and public trial, open to the public. Oh, so if the press were to watch it, they could say, we didn't think it was fair. We thought it was a complete sham. Because remember, the king didn't like to be criticized. A right to a civil trial. Can you imagine that? I mean, you never used to get that. Go to the king's judges and that's it. 10th Amendment, everything not specifically delegated to the federal government in the first three articles is specifically reserved to the states, right? And what's really articulated in the first three articles as it relates to the powers of the United States? It's pretty simple. The borders, immigration, trade, and military. That's about it. That was about it. It wasn't until really FDR, not to get political, but he's the one that wanted to stack the court to get through because the courts kept saying, you can't, this is unconstitutional. You don't have the authority to do that. Nowhere do we have the limits. And so they basically got scared that they were going to pack the courts like they make all the threats now. Well, if he doesn't change his mind or put somebody on the court that we like, we're going to stack the court. That'll get them to change their mind. I mean, it's all the same. Nothing has changed at all, ladies and gentlemen. Go back thousands of years. Human nature doesn't change. Everybody thinks it's all going to be different. Everybody thinks that human nature is going to change. It is not. It never has. It never will. go back if you ever have a chance. Go to an old library, old law library, and go look at the old books that are on there. Where sometimes the language is a little hard. The petitioner and the respondent, you're like, well, is he a defendant? You got to read it very closely. But go back and read those cases. Most of them are criminal cases because that's what goes up on court. The civil stuff usually settles, even back then. And then you look at those old cases, and all that stuff is the same. The same crimes that are being committed, the same reasons that people are committing crime. Sex, drugs, alcohol, lust, all that good stuff. That's the reason. Same thing. Nothing has changed. Sex, drugs, and alcohol, ladies and gentlemen. That's why I will always have a job as a criminal defense attorney as long as they let me keep my license and as long as human nature exists. You're not going to change it. I don't care what people think. It's not going to change. The reasons why we've had prisons over the last thousands of years is there's always been bad people. Yes, you can fix some of them. You can reform them. But there's always going to be bad people. And some people, ladies and gentlemen, they're just not wired right. And for you to say that it never happened before, it's an absolute. Let's see. What is this? Peter. Call me out. Especially coming from a military background. Please. All right. And for you, okay. I'm not sure where that started. Let's see here. It looks like, let's see here. Let's go to the super chat. There's one there.
Yeah, we missed a couple, apparently. We missed this one.
Scott, didn't Chad's lawyer ask for cameras too? Yeah, he wanted cameras. Yes. Okay.
Yeah, this one we missed as well.
Clumsy Clairvoyance says, Idaho, so special, they don't have public trials. I've never seen anything like it. Closed courtrooms, never seen anything like it. All right, Peter he's taking, not saying she's going to get off because of lack of separation of church and state, saying that is why. All of the secrecy and behind closed doors stuff. The holy rulers do not want hocus pocus out. Well, I just haven't seen any of it. Everybody keeps saying that the LDS Church controls everything in Idaho. Maybe I'm naive, and I get it. Religious organizations can be very powerful in various locations of the United States or even around the world. I get that. But I haven't seen anything directly. I think that Judge Boyce is just, I think he's just weak. I think he's so weak. He hasn't been on the bench that long before this case started. Hell, he's been on the case longer now as a judge than he ever was as a magistrate before that. And as judge, this is one that just kind of wound up on his lap. I think he's insecure. I don't think he's very confident in the job that he is doing. Maybe he's getting a little better. He's changed his mind on a couple of things. But for the most part, I think he's just scared to screw up. But I think he's screwing up by doing everything in private. All right, Mama Pink has a super chat here. Mama Pink, I took a woman on target handgun training class a couple of weeks ago. We got a booklet on the Constitution, and I find it very hard to understand because of the old language, but I'm trying. Thought this was my handy dandy pocket Constitution. Oh, I have it right here. Well, we can certainly discuss the Constitution. It's pretty straightforward. And when I think most people, when they read it, they will say, well, that, well, how do they get the power to do all that other stuff? Oh, they just made it up. They made it up. Everybody kind of goes along with it. When you read it, if you're, kind of what they refer to as an originalist, you simply take the words as they exist at the time of the drafting. And people are like, well, that doesn't make any sense, Scott. It makes complete sense. Think about it. If you had a piece of property and they used the language at the time as to say you own this particular property, and they defined it as such with the language at that time as to what it meant. And then someone would say, you know what? We don't like the way that rule was used back then. And we want to change that rule. So we're going to take away some of your property because we're going to use a little more a different measurement system. Instead of meets and bounds, we're going to use a GPS grid system. And, we're going to slice up a little bit of property. Sorry about that. But hey, times have changed. We don't need to use that old stuff. It's so old and ancient. But you're like, no, that's what I bought. That's what it was at the time of the property. That's what it was. You read the language at the time that the document was signed. You don't get to say, oh, it's modern times. These old language words are so tricky and difficult. That's why when you look at Supreme Court cases, a lot of the time they go through the history of the word. What was the meaning of the words at the time? Because it matters. You don't get to put your modern spin just because you don't like the result you're going to get. And remember, if you don't like the Constitution, you don't like an amendment, you want to get rid of it, there is a method of changing the Constitution. We've done it, 26 times, I think, added various amendments. Go change it. But you can't have the courts come and say, well, that just doesn't mean what it says it means. Nope. The times have changed. The right to bear arms, the right to bear arms at the time was you have a right to defend yourself with the weaponry of the day. And not say, oh, you get a musket. No, the court has said it changes over time, basically. You get to defend yourself, basically, whatever is available predominantly during that time period. And they knew that was going to change, and they discussed that because people already had concerns, because there are already people back then that said, you shouldn't have firearms. You shouldn't have guns. Anyway. All right. Wow. Can you believe it's already been an hour? It goes by so fast. It does. Yeah. The Constitution, it's amazing, fascinating document. And to think that those guys and all the people that were here at the time were as bold as they were to say, we're not going to sign that until there's actual restrictions. Because why? People didn't trust the government. Let's face it. The government has been doing people dirty throughout history. Do you really think they're going to change just because you put a couple of restrictions on them? No, they're going to do everything in their power to get around those restrictions because that's what people in power do. They want more power and they don't want to give it up. It's that simple. Feels so much better. Good question here, and then we'll go. Grumpy Cat. Does anyone know if Alec Murdaugh is found guilty of financial crimes, will be transferred to a federal prison or stay in state prison? State prison as it remains right now, simply for the fact that all the crimes have been charged in state court. No federal charges have been pending or filed as of yet. His friend who worked at the bank, where he said he knew nothing about this and blah, blah, blah. And I can't think of his name off the top of my head, but he was convicted in federal court in Charleston. He's going to go do some federal time. So anyway. All right, we're going to go do our Patreon show. If you haven't become a member, now would be a good time to do so. And we'll give you the secret call-in number, and you can ask a question. Oh, looks like we got one more super chat. Can you send a pocket Constitution and wallet card if I send my address to Frank? I'm curious. We need to do that. We need to order Constitutions with CrimeTalk on there. Well, it's the back of my. Don't we have something on the Patreon for the business card on the back of it? I thought we put that up there. Yes, send it, Crime Curious, and Pocket Constitution. We got to order a resupply of those, but everybody should have a copy of the Pocket Constitution. Everybody should read it. I mean, think about it. It's the rules. Who would go play a game not knowing the rules of the game, so to speak? You wouldn't do it. You have to know what to do. How do you know if somebody's outside the lines? You just don't know. All right. That's all we got for you tonight. Thanks for being here for our live show. We appreciate you. Thanks for joining us. If you'd like to be a Patreon, we'll probably be there in 5 minutes or so. So have a wonderful night. We'll see you next time on Crime.